morning, everybody, and welcome to this talk on sports safety. Thank you, Luke, for agreeing to help us as you always do. A very special welcome to our Anglican brothers and sisters, and to Jacques, the Director of the Anglican Board of Education. Sister Kathy, the Director of the Catholic Board of Education, will be joining us shortly. Thank you. And Janice, the Director of the CIE, is with us, so thank you for being with us, Janice. Welcome, everybody, and we look forward to your talk, Luke. Thanks very much.
Right. Good morning, everyone, and thank you very much for joining us today. This particular topic has become sort of a huge issue around the world, and certainly we've seen very tragic cases in our country recently as well. And I think the big thing I want to do is I just want to start by looking at an overview of what it means to keep children safe in general. And then what we'll do is we'll become quite specific to sport, and specifically sport within the school context. So that'll be the departure point. If at any point in time people want to ask questions, please just raise your hands and I'll ask Anne or Janice to just sort of intervene and say, look, there is a question being posed, etc. What I will do at the end as well is I will give lots of time for people to ask me quite specific questions around the presentation, as well as any potential cases they've got. If not, I will present some cases I have and how those have been managed across time. Okay, so the first thing to understand about the workshop is that the child protection world in our country and internationally is well regulated. The difficulty that we find is often that the systems are not entirely, they don't work in fantastic ways. There's lots of limitations around those systems. And the big issue is that there's a lot of sort of reluctance to engage the system due to misunderstandings, or due to comments that people often make to me, like the system doesn't work anyway, or what's the point, or I don't want to get involved with the police. But what we need to understand is that this presentation is really about how we think about protecting our children within the context of our law, and then obviously with sport there's an international context to consider, and then within the context of the school. So all of those things overlap with one another, and it's in the overlapping that often the gaps appear. So firstly, and obviously I would do this if I was in a face-to-face presentation far more kind of interactively, but I'll just ask you to reflect while I'm talking. So the first thing I ask people when I do these programs is, why did you choose to work with children? Now, there may be a few of you out there who didn't actually choose to work with children. It's something you ended up doing by default. And others of you who did choose, and those of you who chose to work with children may sort of be like me, bald and pulling your hair out and saying, why did I do this? But I think ultimately, the majority of us, we really wanted to make a difference in the lives of young people, and as a result, a difference to the future of our country. So we want to make a difference in the subjective experience of children at the time they're going through various phases of development. And within the teaching context, we know we've got lifelong development, so children need they need lots of things, but from a Maslowian perspective, they have basic needs which need to be met, which often in our context aren't. And after that, the next level they need is to be safe. Now, if children do not feel safe, they cannot learn. So that's across the entire lifespan. But then across life stages, children have various needs. And we know that by when we teach them to read, by when we teach them certain mathematical sort of concepts, and introduce them to sort of various levels of volume of work and complexity of work. And the big thing in that is that we are here to ensure the optimal development of children. And the optimal development of children presupposes that they feel safe. Because as I said earlier, if they don't feel safe, they cannot learn optimally. So safety is a precondition to learning. And where children are not safe, it is a barrier to learning. From an education context, we need to mitigate against. So that's the context of it. And the Spider-Man lesson is one where with that level of power, knowing that we are almost sort of, kind of almost gods of children's childhoods in terms of their learning and what we can impart, we have to recognize that there is a very, very big level of responsibility that is bestowed on us. And I mean, I know from my childhood, I can think of educators that, I mean, to use a very strong word, because, you know, I have no other word to use, that I hated, you know, that made subject intolerable for me. They were bullies. They made my life, you know, at school in the south at Joburg intolerable. Whereas I equally had educators who are one of the biggest reasons I am where I am today. They were absolutely aspirational, they were inspirational, they were motivational. They changed the way I thought about the world and myself and about the people around me. I mean, extraordinary characters in the lives of, well, in my life and in the lives of those around me. And equally, we must recognize that those of us who are adults working with young people, that we work with young people that we really like. So there's some young people who make us feel good about ourselves, good about our coaching, like my SA champs. I've got 2 SA champs this year. They make me feel wonderful because, sure, you know, I've generated 2 South African champions. Equally, we have children that we struggle with the projections that they put on us. And there's some children I work with that I really struggle with. And for me, it's hard to work with them. And I have to always keep in mind that the primary aim is to be professional. And when we tend to revert to personal ways of being in the world, it is when we don't have the necessary professional sort of boundaries within which to operate. Okay, so the big thing is that we all have a negative duty towards the protection of children. And that's, as I've said, do no harm. And as I said, it's easier to work with certain children, harder to work with other children, easier to work in certain contexts, harder to work in others. But ultimately, we have to maintain the professional boundary, and we have to make sure that we are responding in the most professional way that is possible and checking ourselves all the time. However, this talk in particular is more than the first do no harm principle. It's talking to our positive duty. And our positive duty is the things we must do to keep children safe as the duty bearers to children's rights within the South African context. And ultimately, what we're trying to do is generate a world fit for children. And as I said at the beginning of my talk, is to ensure their optimal development. The law provides us with that guide. And I'll come back at the end to other international sort of things we need to think about. But the context of our child protection and child rights work and child development work is the United Nations Convention on the Rights of the Child. So the UN Convention has been signed by pretty much every country in the world with the exception of the United States. And it gives us a guide to what the minimum standards for children's rights are, recognizing that children are afforded certain rights. Those are indelible rights. They are rights we cannot remove from children, and that we as adult duty bearers, we have a duty to ensure that those rights are met, obviously within our abilities, because there are limits to it, which we see in our country all the time. Within our continent, there's an African Charter on the Rights of the Child, and that African Charter just simply makes the International UN Charter more specific to our continent. And while those 2 international treaties are important, is that they pretty much govern everything in terms of how we deal with children. And they are the underpinnings of our constitution. And within our constitution, the overriding principle is that we act in the best interests of children. Now, that's not always as simple as what it may sound, because sometimes children, depending on their age and their ability to understand and consent to things and their criminal capacity, it's not always easy to understand how we balance child participation with us as sort of adult duty bearers. We're struggling to balance, the parents and I are struggling to balance this young lady of 12's rights to, for us to not go and talk to the school about what's happening, with our duty as adults to say we do need to talk to the school about what is happening, because, you know, there are other children involved and your well-being. And at 12, you know, you're going through puberty and your brain is on fire, you know, because of your development. And we need to, unfortunately, make some decisions on your behalf. And that becomes quite complex around what is best, because sometimes it goes against what the children may be explicitly asking us to do. And that is really important when we consider the concept of confidentiality, because within the context of child protection legislation, you can never, ever promise blanket confidentiality. This has become a huge issue within the religious context, and specifically the Catholic context, with the idea of the confessional and what the confessional holds. And if people are telling you things within the context of the confessional, are you bound by the confessional, or are you bound by the laws of our country, which supersede those, which are then informed by international treaties and laws, etc. Okay, so the big thing in our Constitution is Article 28. It's something that I use a lot because it provides the foundation for all rights children have, and those are these inalienable, indelible rights. We can't use them as a form of discipline. So in other words, you can't remove a child's food as a way to discipline them for your idea they must behave in, because they have a right to care. You can't kick them out the house because they have a right to shelter. So there's certain things we can't use within the context of discipline. We cannot remove those rights. We cannot infringe on those rights when we are acting as duty bearers, because we are there to make sure those rights are met. So the way I use it in our programming, so where you see in the background where I'm sitting now, I'm sitting at a boxing gym I run within the sort of inner city Joburg Hillbrow community. And when you walk into the gym where I work, the first thing you will see on the walls is posters of children's rights, children's responsibilities. There's already GBV posters. There's information up on the cycle of violence and the circle of care, so that when children enter my gym, they know that this is a place where we take their safety seriously. We've got all of our guardian certificates up on the wall to say we've all been checked against the child protection sexual offenders registers. I've got my occupational health and safety certificates on the wall, because the environment in which children find themselves needs to contain them. And look, within the school or the classroom context, we need to be able to show children that we can give them a script for their rights, because children cannot claim their rights unless they are aware of what those are. So an example I've given in this slide is that the first right of all children in our Constitution is a right to a name and nationality from birth. So the importance of that within the Joburg inner city context is that we have many children who come from other countries, other provinces, and the children come and they are not documented. Now, if you do not have a birth certificate, some form of maybe clinic identification or asylum seeker, refugee permit, or whatever the piece of paper is, you essentially become a ghost and you cannot access any of your other rights. So what happens is I will make that quite explicit, and I will ask them, well, in order to be a boxer, you need to be able to register as a boxer, and to register as a boxer, I need to know who you are, so they know that the right person is in the ring, so that it's fair, and I need your papers. Now, when I can't get papers from them, it's at that point that I need to intervene as a duty bearer and say, what is the barrier to getting you papers? Because I need to get you some form of identification, otherwise you're essentially a stateless ghost, and if you are that, you cannot access any of your rights. So the whole programming is informed, my whole sporting programming is informed by the fact that sport offers me an opportunity to see where the gaps are. Safe spaces, which is what I've just explained, I need safe people. Now, the first, and I'll get at the end, I'll get to where this is limited in sport, and it's a really big concern for me at the moment. But let's just start with where we can go and then go backwards to where the gaps are that need to be filled. So in order to, in my gym, in order for me to employ a coach, they have to have a once-off criminal record check, and that is mainly for people that are older. You know, as you can see, I'm sort of in my sort of early 20s, not so much. I'm in my early 50s, and as a result, what you have in my context is that I may have committed an offence prior to the new legislation, which is the Sexual Offences Legislation and the Children's Act, and I may have an prior to those acts coming into effect, which means I will not be on the sex offender register or the child protection register. And as a result, I want a once-off criminal check. Now, the hesitancy for people to get criminal checks is, what if I've got a criminal record and then it destroys my career? Well, you have to make it overt that it is not all criminal offenses that exclude you working from children. So, for example, if you have a shoplifting offense, does that mean that you can't work with children? Well, it might be the reason I employ you, because you are someone who was in conflict with the law, who can warn children against what it is like to be a young person who takes things that don't belong to them and ends up in conflict with the law. So in fact, sort of in our sister organizations in Cape Town, they would specifically hire people with criminal records who have been in prison to warn young people through the boxing around the fact that if you carry on along this sort of drug path and the gang path, this is where you'll end up, and it's a warning against it. So having a criminal record does not exclude you from working with children, but it has to be made quite overt and quite specific. The two other registers, the one is the sex offender register. That register is relatively easy to access. There's many organizations out there at the moment who offer these checks. They obviously come at a fee because there's technology involved. What we do is we hire a company that come to us, and they take all of our fingerprints, they send away our IDs and our documents, and then they do the checks for us. So it's done completely independently of us, and they issue us with certificates against that sex offender register. Now that register is in terms of the Sexual Offences Act, and that register is of people who have been convicted of sexual offences against children and people with adults with cognitive impairments, whether those are sort of permanent or temporary, but it's against disabled people. It currently doesn't include sexual offences against adults, but the criminal check will include sexual offences against adults. So that's the sex offender register. The other register, which is the one that is broader but is more complex, is the Child Protection Register. Now, that register is in terms of the Children's Act, and that register is a register of people who are considered unsuitable to work with children. So in that instance, you fill out a Form 29 that is to be filled out by the employer, and the employee fills out a Form 30. So the employer has to be mandated by their board, their SGB, or if you are a government school, by the department, to check your staff against that particular register. And what that register essentially does is it has a list of people who are considered unsuitable to work with children. Now, in simplistic terms, at the moment, as far as I understand, is the Child Protection Register and the Sex Offender Register names are largely the same people. Because if you are on the Sex Offender Register, you are automatically on the Child Protection Register. And there are other reasons you can end up on the Child Protection Register, like I know SACE. If there's a section of the Employment of Educators Act or the SACE Code of Conduct, if there's a sexual transgression that someone is found guilty of in a labor hearing or a SACE hearing, they would also send those names up to the Child Protection Register, because it's a formal legal process that has found them guilty of something that makes them unsuitable to work with children. Now, unfortunately, that register is not working fantastically. And it has taken us the last time we sent our documents up, it actually came back in 3 months, whereas the sex offender register you get back in like 10 days or 2 weeks. But it took about 3 months. And some people have told me it takes as long as 6 and 9 months because of COVID. But the point is that you do it. And the point is that the people who apply for jobs with me at the moment need to have done this, or at least showed me that they have submitted those documents. What we do is we courier them. We make sure that there's a waybill number so we can track the documents, because they tend to get lost. Okay, so that's the context of people who are not allowed to work with children. At the end, I will be moving more on to how we ensure that we are employing the correct people. So this is again part of that negative duty. And if coaches apply to me without these documents on their CV, and another one which I'll mention at the end, I won't even look at their CV. Then what happens is that once we now have safe spaces and we have safe people, we need to know that if something goes wrong, what are we bound by? And we are bound by what I call the matrix. And those of you who have seen the movie The Matrix or the movies The Matrix, you'll know it's an enormously complex thing with a whole set of sort of letters and numbers flowing down in code over a black screen with green numbers. And that is very similar to how our law works. And the idea about looking at it as a matrix is it is a matrix. Things interlock over one another. And if you are going to think correctly about how to intervene and keep children safe within the school sport context, you need to understand how those things interlock because they affect our decision making. So the first thing to understand is that the CAAA is the Children's Act as amended with pending amendments. So the reason I'm a little bit facetious about the fact that it's the Children's Act as amended with amendments is the fact that you must understand that the law is an organic, dynamic thing. It is not static. So what happens is that we recognize there's gaps in our law, we recognize there's changes. So you have to make sure you have the correct versions. And also, as has happened with, particularly within the South African religious context, is when people are unhappy about what the government are proposing, like banning corporal punishment or introducing comprehensive sexuality education. There are amendments around that, and there are public processes by which you can actually participate in those. And we participate in those law reforms all the time. So it's not that you don't have a voice, you just need to keep up with where those voices are. The two pieces, so that's a very, very big piece of legislation. And the two sections you need to know, not know offhand, but you need to know where to find them. You should have them on record. You should have a printout of them on a file in your child safeguarding file, is sections 110 and 150. Section 110 is the section that talks about the mandatory reporting of knowledge that a child has been abused. Now, the important thing is that the first thing to understand is the word knowledge. Excuse the coffee, it's just lubricating my voice at the moment. The first thing to understand is what abuse is, and abuse is in section 150, and there's a long list of things that are abuse. But the important thing for you to understand is that what you must report is physical abuse, sexual abuse, and deliberate neglect. Okay, so physical abuse in our context has become quite complex because corporal punishment must be made unconstitutional. So that has become a real challenge. And then also within the context of sport, if you are giving children physical drills where you are drilling the first team captain of your rugby team who's a super athlete and somebody who's a child who's more artistic or cultural and is not a natural athlete, and you're making them all do 100 push-ups. You know, the idea that they should all do 100 push-ups doesn't make any sense, because the boy with who's the head of the local rugby team may be able to do it easily, whereas the boy who's a more artistic, cultural, who's not a very physical child, he may not be able to do 10. So there's a level at which we need to be careful of the socially sanctioned deviance of sport around the sort of hyper performance and using push-ups and sit-ups as a form of punishment, because there is a level at which that can be physically and developmentally damaging to children. Sexual abuse isn't complicated because it's anything sexual relating to children. Asking for images, sending images, sexual words, sexual sounds, touching children, raping children, etc. And all of those are equally serious. I was recently in a Law Reform Commission working paper where there was kind of this debate about the fact that principals are defining what is and is not serious, so whether it constitutes a transgression in terms of Section 17 of the Employment of Educators Act. All sexual things are serious, okay, within the context of the law. Okay. And then deliberate neglect is important, because deliberate neglect is not, you've got, a family like I have in the inner city, and they are struggling to find employment and make ends meet, and they're struggling to provide adequate housing, adequate fooding, adequate clothing. They're not deliberately neglecting their children. It's systemic. And that is very different from the cases I deal with, for example, where parents put their children on the front seat of a car, they don't put their children in car seats, they don't put the seatbelts on, they're sitting on the parents' laps. The child has, the car has an accident and the child gets injured. Or you have a pool at your home, you don't put a fence around it, you've got small children around, they drown. or cases I testified in at the end of last year, where children were sort of systematically murdered by their fathers, stepfathers, moms, boyfriends, and the mother stood by and watched and were then charged with deliberate neglect and got between 10 and 20 years imprisonment because they did not exercise their duty to actively protect. Now, what is important to know is that if you know a child has been abused, they've told you, there's medical evidence, physical evidence, which you don't find, you refer the children and the parents or whoever it is that's looking after the child to doctors to find the medical evidence. It is witnessed by somebody, okay, or that's sort of like the context where the child has told another child who then tells us as adult duty bearers, because it is not your job to determine whether there is guilt or innocence or whether the child is telling the truth or not. That's the job of the court. Your job in terms of section 110 is to request an investigation. So you're not making an allegation. You're not making an accusation. You're requesting an investigation into the circumstances giving rise to your knowledge that the child has been abused. You report it either on a Form 2. So Form 2 is a direct report to the Children's Court where you request the court to appoint a social worker to a family. And I'll explain when that is most often used in my second form final slide. Or you can use a Form 22 and a Form 22, or you can use both. A Form 22 is a register where we submit the Form 22 to the department. Now, submitting that Form 22 doesn't activate an intervention, because sometimes we offer the interventions to the families, and then we submit a Form 23 to close it, okay? And then the regulation is a Regulation 33, and simply that regulation is just tells you how to use the law. And if you just ask Karen, she'll send you through, which you may have done already, the basic manual with the forms attached to it, which is the minimum standard I'm going to talk to at the end, because there's a minimum standard. Now, if you suspect a child has been abused, you may report it. So in other words, you can report something at any point in time, but knowledge you must report. And if you don't, there is a legal sanction. So it's a fine or imprisonment. And if you do report it, on a Form 22 or a Form 2, in terms of the legislation and the regulation, you can't be sued because you reported it in good faith in terms of the regulations. And what you must also understand is that you are not making a finding, you're requesting investigation. So what you'll do is you'll report what you heard, what you saw. You won't report what you think, because what you think is not relevant to the law. What the child has told you verbatim is what is important. Now, it's significant to note that, and we're fighting this at the moment with the parliamentary thing that we're trying to do on the 27th, during the 16 days of activism, sport is not mentioned. Coaches are not mentioned within section 110. Now, we largely believe that that was an oversight, but for us, that doesn't change your moral and ethical responsibility within the sport context to behave in the spirit of the law, because it's an oversight rather than a way out, if that makes sense to people. Then the next thing to understand is this long acronym, which is the Criminal Law, Sexual Offences and Related Matters Amendment Act. And that piece of legislation is broadly known as the new sexual offences legislation. And that sexual offences legislation replaced the previous one, which was largely the Immorality Act. So it's a very complex piece of law to read. It's written in a very difficult way to understand. And the big thing is for you to understand Section 54. And Section 54 says anybody who knows a child has been sexually abused in any manner whatsoever must report the case immediately to the police. So the Children's Act requires us to complete forms and submit those to the Department of Social Development or the court or both. And if we want intervention, we must ask for it. Whereas the sexual offences legislation says anybody. So the Children's Act is mentioning certain professions. The Sexual Offences Act says anybody. So if you have a sexual offence, there's a dual mandate to report to the Department of Social Development and to the police. Okay, and that is in the form of a police statement. And if you are the first person that the child is told, you'll be required to make a statement and you will be a witness in the case. So it's important to take notes and write down verbatim what the child has said, not to interpret it, not to change words like stoat things to abuse, not to translate cookie to vagina or whatever. You are not there to interpret, you are there to verbatim say what the child has said to you and then report it for investigation. So again, much like the complexity around corporal punishment, there's a huge complexity around what to report around sexual offences. The basic rules are as follows. If a person does not consent, age is irrelevant. So if you're 0 or you're 150 and you don't consent to a form of sexual contact, you've either been sexually violated or exposed to voyeurism or frotteurism or rape, and as a result, your age is not relevant. Where it is relevant is only children, is there a must report clause, and people with a cognitive impairment, there's a must report clause. Adults who report things when they're abused as adults, they can choose to report should they wish to. There's no legal mandate to report. Because this is a school context, it would be, there's always a legal obligation to report to the police to hold a criminal investigation. Whereas the Children's Court activates a Children's Court investigation, which I'll clarify at the end. Then, if a child is under 12, consent is irrelevant. So, for example, I had a man come to me and he was a stepfather of a 5-year-old and said to me that he's in big trouble, he needs to talk to me. I said, fine, I need to warn you that anything you tell me, I might need to testify in court about and report. Secondly, I'm going to need to get somebody in as a witness to make sure I've heard you correctly. And thirdly, I need to record it in writing. And if you're happy with that, then I will listen to what you have to say. Because if you don't want to tell me, that's one thing, but if you do tell me, these are my obligations. And I say the same to children who want to tell me things, except I'm obviously not as sort of hard. I say to them, you know, I can't guarantee confidentiality because sometimes the law tells me to do things to keep you safe. Okay, and those are, if you're being hurt, somebody else is going to get hurt or a crime is going to be committed. And those are the basic rules. Okay. So under 12, he then said to me, his 5-year-old daughter bounced up and down on his lap. That made him aroused. He asked her, could he have sex with her? She said yes. She's 5. So the court says, you must be mad. You know, how do you possibly think that a child at 5 can consent? Plus it's incest, so you can't consent anyway. But that comes from old Roman Dutch law. So under 12, children can consent to nothing. Over 16, children can pretty much consent to anything that they want to consent to, other than being online, sending images online, because that's all child pornography until the age they turn 18. And then, you know, sorry about the trigger warnings around sort of the next two concepts, but things like bestiality and necrophilia are completely illegal regardless of your age. Now, I mean, it sounds bizarre that I'm mentioning things like bestiality, but I had a report from a religious school this week of a case where images of bestiality were being sent around among a group of 12-year-old girls. Okay, so it's not something that is not, it doesn't exist. In fact, it's rife online. I've had more than one instance online, and I've had cases sort of in the real world where I've had to intervene. So those are completely illegal. Okay, but over 16, apart from online and those two parameters, pretty much whatever young people want to do, they can consent to. So that leaves us then with the age category of children 12 to 16. This is the complex part of the law. So the Sexual Offences Act has been amended, and it has made sections 15 and 16 of the Sexual Offences Act unconstitutional. And those were the sections that dealt with the criminality of consensual sex between children 12 to 15. It is not a criminal offence anymore if children 12 to 15 have consensual sex with one another, provided that both consent to the sexual encounter. The day one of them turns 16, the person younger than them cannot be more than 2 years younger than them. So 12 and 16 is a criminal offense, but 15 and 16 is not. 15 and 17 is not. So the day one turns 16 before they turn 18 and become adults, the other one cannot be 2 years younger than them, otherwise an offense does arise. However, I'm like a very marked advert, and the very marked advert, and there is more. The next abbreviation, which is the CJA, determines criminal capacity. So in other words, the person committing the crime can understand the wrongfulness of the act, the consequences of the act, and can act in accordance with those two things. And the Child Justice Act says children under 12, which has changed from 7 and then 10, and it's now up to 12. Children under 12 have no criminal capacity. So they're dealt with in terms of Section 9 of the Child Justice Act, which is a set of therapeutic, familial, and other interventions, but you cannot have a criminal outcome. It's not like in the Jamie Bulger case in the UK, where all movies you see about America, where you can make an application to have a child tried as an adult. There's no such thing in our law for children under 12. Children over 14 have automatic criminal capacity, but it is a last resort that they go to jail. They do for very serious offenses, and I've dealt with children of 14 in prison who are serving 35-year jail sentences. When they become adults, they move them from the children's wing of the jail to the adult wing, but those are very, very serious crimes. Most of the time, what we're trying to do is diversions, and that means diverting children away from the criminal justice system into registered accredited therapeutic programs. Teddy Bear Clinic does one for sex offenders, Sanka does one for drug abuse, NICRA does them for other offenses like theft and shoplifting, Kulisa does them, but they're accredited. That's not your local therapist, they're accredited programs. So then that leaves us with children 12 and 13. And children 12 and 13 are assumed to not have criminal capacity unless the state chooses to prove they do. And I've only in the history of my entire career had 3 times where that has happened, and I've got one pending now. So in my whole career, it's only happened 3 now, maybe 4 times. And that is generally with outside interference, political interference, media interference, custody access divorce cases with the interference of disgruntled exes, etc. It's not what the state wants to do. So if they don't have criminal capacity, they're treated as if they're under 12, and if they're found to have criminal capacity, they're treated as if they're over 14. Okay. Does this all make sense so far? Any questions? I'm going to pause now, because if you have questions, this is the end of the sort of laws and the ages of consent, because there are a couple of others which you need to know but are not essential in terms of your kind of way forward. Okay, so in terms of our constitution, you are a child until you are 18. The age of 21 no longer exists. So in terms of the Children's Act, that first one, when you report things, the reports are all around people under 18, whereas when you come to the Sexual Offences Act, it's up to 16, with the exception of, like I said, pornography. But the Sexual Offences Act also looks at the cognitive age of people. So it also includes adults with cognitive impairments, and those are either temporary impairments, like if someone has a manic episode, or they are permanent impairments, where someone, for example, has a syndrome like Down's, and as a result has an intellectual impairment. So the Sexual Offences Act also considers the mental age of an adult in terms of their ability to consent. And in fact, for those of you working with adults who are cognitively impaired, there is a higher reporting mandate, because for children you have to report knowledge. You may report a reasonable belief or suspicion, but for people with cognitive impairments, you must report a reasonable belief or suspicion for adults who have cognitive impairments. So there's almost a higher duty to protect cognitively impaired adults in the sexual offences legislation. So the age of 21 at the moment is nothing except a key and a party. It doesn't exist. So there's no age of majority anymore. It's a fantastic question, because it's a lot of what we're dealing with within the context of our cases at the moment. So what we have around the concept of consent is a set of quite complicated things young people are required to understand, which us as adults don't even do, frankly. and then we're expecting children to negotiate them. So, for example, the current guidelines on consent are more or less the following. Number one, you have to be of age to consent. So that's the first thing. Number two, the other person has to be within a reasonable age category to you to consent. So that's the 12 to 15, 15 to 17 scenarios are painted, because there's certain age gaps where you can't consent and there are defined lines. But let's take the ones where you can consent. So that's the 12 to 15, 15, 16, 15, 17, 14, 16. In those instances, the first thing is that the consent is not made under intoxication. Now, that's become a really complicated story for us, because now the intoxication has become common and people are initiating things, not knowing when to stop, not understanding that they were asked to stop. The people who are not stopping the people from the sexual contact are saying, but I did try and say something, but I couldn't because of the nature of the sexual encounter or the nature of my intoxication. And unfortunately, because we know from good neuroscience that adolescent brains are the equivalent of giving unlicensed drivers Ferraris without brakes, add a little bit of marijuana and alcohol to that, you now have nitrous and a turbo on top of this brain, and the ability to make informed decisions is extremely poor. So the first thing is that intoxication assumes no informed consent. So that's the first thing they need to understand. So if you're going to get intoxicated or have a sexual encounter with an intoxicated person, the chance of there being a comeback is high. That's point one. Point two is that consent to one level of a sexual encounter does not imply consent to the next level. And this has become a really, really complicated thing. And I'll give you sort of a case example of that. The next level at which is you can withdraw consent at any point you become uncomfortable within a sexual encounter. That has become complicated, and in fact, let me give you a case example. So within the religious sort of school context, I had a case, and it involved particularly two teenagers within the realm of consent. So they were within the ages at which they were considered capable of consent, and it went through kind of the usual stages of getting involved and hooking up, and then kissing, and then touching, and then it ended up at oral sex. And what happened is they were both intoxicated. And what happened at that point is, due to the nature of the oral sex, and particularly the pornographic script that has become associated with oral sex, there was what was considered to be force and the inability to say no, because he was holding her head and she couldn't talk because of the oral sex. And when there was a disengagement from that, there was a level at which that point she said, I absolutely did not consent to that, but there was no way I could voice that other than just sort of in my body pulling away. And that, because of the pornographic script, because there's a lot of force involved in the pornographic script, was seen as part of the sexual encounter by the intoxicated boy. And that ended up in a massive issue, because that's rape. Because any form of penetration is rape. So now suddenly you've got a 17-year-old boy being charged with rape, where he's saying, but I had absolutely no idea, because the script that he had was one of the pornographic script, and sex being a consumer-based thing, and not understanding that this kind of resistance was a way of denying consent at that point in the sexual encounter, because it got progressively more forceful and started choking her, and she wanted to withdraw the consent in the middle, and he said he didn't understand that. Okay. So it is not so much enthusiastic as progressive. So in other words, it is consent to see that somebody is okay over a period of time during an encounter, because consent progresses along the course of the increasing intimacy and sexuality of a particular encounter. There unfortunately has become a higher burden on our young people, because the scripts have changed dramatically. Next abbreviation, the COTOPA, is the Choice of Termination of Pregnancy Act. And I know that is another very big sort of complex issue, along with spare the rod and spoil the child and all the other things, that have religious value basis as opposed to legal basis. But the thing to understand is that the age of a person is not what is relevant for consent to a termination of pregnancy. The term of the pregnancy is what is relevant. So any woman can terminate her pregnancy from the day she can become pregnant. Age is not part of what is considered in terms of consent for an abortion. What is considered is the term of the pregnancy. So in the first trimester of the pregnancy, there is no conditions whatsoever. Anybody can terminate at any level. And I always sort of jokingly say this to people: for the men in the audience, a trimester is the sections of 3 months in the 40 weeks of the pregnancy. So in the first trimester, no conditions. Second trimester, conditions are things like abject poverty, the fact that the mother's life is at risk or health is at risk, the child has a non-viable medical condition like trisomy 18 or something like that. And the third trimester, very much the same, where the child is a product of rape or incest, or the child has a genetically transmitted disease that is seen as incompatible with life. And in fact, I have a close friend who, him and his Catholic wife, were offered a termination at 8 months of their pregnancy when they found out that their child had tuberous sclerosis, which is a very life-limiting condition. So that's a termination of pregnancy, and it's all about option counseling. And then obviously children are not allowed to drink, they are not allowed to smoke, they are not allowed to vape, they are not allowed to smoke marijuana. Marijuana is not legal within the context of children, and all of these mythical creatures around CBT and THC and vaping with things that they call Dutchies, things like canna, they are all illegal, okay, including what parents allow as the slippery slope around the Film and Publications Act, which is allowing their children to play age-restricted games when they're not supposed to, allowing them to be on age-restricted social media platforms, allowing them to watch age-restricted movies, and then they wonder why their children drink and smoke because they haven't paid any attention whatsoever to the fact that our government has legislated ages. All of that should not happen. Okay, it's neglectful and sometimes frankly negligent. So what are we then to do? We are then there to be advocates for the rights of children. We need to observe, we need to listen, we need to communicate, and ultimately we need to be unpacking for children what, who, when, where, how these things happen. We are not there to investigate the matter. We are there to gather sufficient information to make sure we fit our reports and requests for investigation into the categories I've explained in the matrix. I've done that. Okay, so what are the factors we need to consider? So the factors we need to consider is, when did the offense occur? Now, we're in a big debate at the moment with the prosecution. We're trying to launch cases within the sporting context, where adults have reported cases of the fact that they were abused as children in the sporting context, and the federations have done nothing. Now, what has happened with that context is that within the context of that, we are having a debate as to whether what the law intended was when it says we must report the abuse of a child in terms of the Sexual Offences Act, but we don't report adults. So if an adult is telling you when they were a child, do we report it? So what I'm saying is, I would much rather ask the adult, why are you reporting it to me now? And what do you expect from the intervention? Because dealing with adult survivors is a chronic case, and there is there's no urgency about the fact that the person is currently at risk or in danger. Whereas an acute case, which is a case that has happened within the last 72 hours, comes with a whole lot of important things that need to be done. Specifically, if you look at the bottom, which is the triangle of intervention, there needs to be medical intervention in the first 72 hours to prevent the ongoing or the potential long-term consequences of, for example, a sexual assault, which is pregnancy, HIV, STIs, etc. They need post-exposure prophylaxis. Also, within the acute phase of the 72 hours, you're more likely to find forensic evidence, which is secondary, semen, hair, skin, etc. And when the case is chronic, you've got none of that. So there's a level at which the chronic cases on the triangle of intervention are more care-based. What makes you tell me now? what are we wanting to achieve by this disclosure? Is it therapeutic? Are you worried that this person is still abusing other people? What are we trying to achieve by the intervention? And all of that is framed in the law that I told you. The second factor is the relationship between the person who has abused the child and the child. So intrafamilial cases, so in other words, cases that are happening inside the caregiving home, so inside the place where the child is being cared for. Now, for example, in the case of a school where there's a hostel, that's the place where the child is living. So the hostel would be intrafamilial, because that's locus parentis and caregiver and so on. And acute cases, so cases that have happened in the last 72 hours that are inside the family or the caregiver context, are your most complex, because you have to evoke the Children's Act to keep the child safe, and you have to evoke the criminal system to make sure the offender is managed. Okay, and then, as I've said, the extrafamilial cases and the cases that have happened years ago, so a coach that abused somebody 20 years ago, far more, you can apply far more kind of thought and finesse around those cases, because the person's not in immediate danger. The case happened a long time ago. It's not somebody in their home, so you can think a lot more about those interventions. Then the other one is, very importantly, the age of the accused, the age of the offender, because if that offender is a child themselves, you have to understand that that child has rights in terms of the Child Justice Act and needs to be dealt with in the restorative justice process through the criminal justice system, but is treated very differently from how we treat an adult. So there's a level at which we need to consider the rights of the child in conflict with the law, whereas if it was an adult, they can manage their own rights, because then they're governed by the Criminal Procedures Act, not child legislation. And then we need to recognize that when we intervene, we can potentially pose risks to young people and their families by over diagnosing things or underdiagnosing them. So too much sort of involvement and freneticness, where we're supposed to be looking at the most empowering, least restrictive options, too much freneticness can cause harm, and too little intervention can also cause harm. So it's kind of a balanced middle road, wisdom of Solomon, thoughtful process, because reporting these cases and managing them is an art, and it's not an event, it's a process. So we need to always measure the potential risk of our intervention against the potential benefits thereof. Okay, so the points of entry are many. So the points of entry are schools, hostels, sports coaches, priests, clerics, admin people, other children. There are many points of entry where children come in. But the importance of the point of entry is children need to know what we are required as adults to do to protect their rights as their duty bearers, so that when they make disclosures to us, those disclosures are purposeful. In other words, they've thought through the consequences of their disclosure. That's the important part. Okay, so in that context, we then need to recognize that children need to be educated and given the script for these things, so that they make these disclosures purposefully. Accidental disclosures, which have happened as a result of for example, medical evidence or being witnessed, they're far more difficult to deal with, because the young people haven't made the decision to disclose yet and haven't thought through the consequences. The thoughts around ADR, that's alternative dispute resolution. Those are things like mediations and sort of ways that we deal with cases that are not within the legal context. Those have to be approved by the legal system. We can't do them instead of. Here's the gaps in sport. So sport has become a real challenge, and in fact, there's which I can also send through to you, and there is an article that came out of, I think, the UK, where there was, or it was Australia, but one of those big sort of inquiries into the abuse within schools and churches and all of that, that there are predators hiding within sport. We call them career offenders. And what they do is they choose jobs that give them access to children. Now, going back to the fact that everybody needs to be checked against the criminal check, the sex offenders register, the child protection register. There's all of those things that need to be put in place. But where we have a problem with coaches is coaches are not centrally registered. So we are having endless issues with coaches. So we've had coaches in all sports like swimming and gymnastics and netball and whatever, all kind of facing charges and criminal, investigations, etc. And when we ask the federations, like, yeah, can you please intervene? Oh, no, they're not registered with us. So, but how can they coach? Oh, no, they don't have to register. So now, a coach can come because a coach is like, you take the Parktown Boys High case, he comes in as a water polo coach and a pastoral care person and a hostel master, etc., simply because he was at the school and he was a good water polo player. So he's an old boy, he was a talented water polo player, but has no qualification, skill, regulation relating to him being able to coach children. So they're not centrally registered. There is no central register of coaches. And in fact, even if they are registered with the federations, we don't really know what the federations do about the registrations because they're registered to teach sport. That doesn't mean they have any knowledge whatsoever around child development, child safety, child protection, which they're obviously trying to introduce now, but certainly doesn't exist on a large scale and certainly hasn't existed in the past. So the idea that a coach is not registered with a central authority like a SACE, where there's a minimum sort of minimum standard or a minimum framework for these young, or not always young coaches, but for coaches who then want to come and coach is a problem. So what we do is we look at the spirit of the registration. So the spirit of the SACE registration is if you are registered with the Council for Educators, you have an education qualification, whether you teach in an IEB school or a Cambridge or a DBE school or whatever, you need to be registered with SACE. And my assumption is that you are taught to work with children, you taught pedagogy, you taught child development, you taught all of those things, and then you teach a subject. So the sport is not relevant. The baseline qualification for me is what I look for, which is a child development, a child safeguarding, a registration and a regulation baseline for employing people. And young people do need to, or not even young people, people need to be given an opportunity to get their CVs up to date in a CPD kind of context to be able to meet those requirements. We obviously don't want to exclude people because now we've made new rules. But for me, child development and child protection are absolutely critical, and the fact that you are not on any of the registers is critical, and the fact that you have some formal qualification to look at how to teach sport, for example, following the recent debates on the detrimental nature of early specialization in sport, where coaches are being forced to do super specializations because the parents are asking the coaches to specialize their child because they want the next Wimbledon champion, but that's not in a child's best interest. So there's all of that complexity around sport and the meaning associated with sport. Okay. Now, SASCOC has a safeguarding committee, which technically you can refer to, but that having been said, SASCOC is SASCOC and only regulates Olympic sports. That's the first thing. And secondly, they seem to have very limited powers because they need to give opportunity to the federations to deal with things, because the federations, particularly the Olympic federations, are registered with international federations. For example, swimming is also FINA, and FINA has rules, and the International Organizing Committee has rules, and so it's a bit of a drama, and the short end of it is they're not very helpful. So you need to regulate it within your school context, because school sports falls between some weird categories. And for me, it needs to be regulated like we regulate educators. They should not be an exception to the rule. We can't register coaches with SACE because there's no category, although we're fighting for there to be one, there isn't one, unless, of course, they're a teacher as well. So that's the problem. And then there's the opportunities we have to make our sport safer within our schools. Obviously, there is political will by our government. You know, the president has his 5-point plan. We have the 16 days of activism against gender-based violence coming up, which is an opportunity to land messages around grooming, gaslighting, how to protect children, how to make sure that there's safety. For example, on the child principles, where there's never one coach, there's only 2 coaches. If there are individual lessons being given, how is that managed? Things like WhatsApp groups. There shouldn't be a lot of current cases And we had a conviction of one in George where he was a pastor and the rugby coach and the Afrikaans teacher and the art teacher, and he was found guilty of grooming based on a set of WhatsApps he sent. Now, I should never have been sending individual children WhatsApps. The parents shouldn't have allowed that. The parent is the one who needs to make arrangements around sport, and the school should never have allowed that, because he's an employee of the school there should be someone moderating communication. So young people need to know that, parents need to know that. So there's all that stuff that we can land, things like parents watching sport. They should have a code of conduct themselves. So when my daughter was at school, she played first team netball, her boyfriend played first team rugby, and we as parents got a code of conduct from the school saying this is what is expected of you and your behavior on the sideline, and should you choose to behave badly, we'll send you home, and we won't allow you on the sidelines anymore, which I thought was fantastic, because the parents' behavior can be equally abusive and problematic on the sidelines. So essentially there's a lot of will around getting this stuff spoken about and getting it out into the public consciousness. So what do we start with? Well, we start with the minimum standard, which is the document I'll send, and which is the stuff you have to do and you have to know. So that's protection under our law. The second is what we're moving towards within the sporting fraternity. We are working with SASCOC and with UNICEF, and with, for example, gymnastics and swimming and baseball and cricket and rugby, and there's a few that have really sort of tried to come on board quite nicely. And that is a combination of the sexual abuse and harassment policy of the Department of Basic Education, which is easily available online, and it deals with all the issues. So it deals with SACE registration, SACE code of conduct. It deals with Section 17 offences in terms of the Employment of Educators Act, relationships between educators and learners, relationships. And now this idea, which we've seen in the cases that have been all over the media and the suicides that we've seen recently, is educators or coaches or both resigning while under suspicion. So it will tell you about Section 14 of the Employment of Educators Act, which will say that you need to charge people up front in terms of the discipline, not have discussions with them, because then they resign and you can't do anything with them. Whereas if in terms of section, I think it's 14(1)(d) of the Employment of Educators Act, if somebody resigns while having been charged under investigation, that charge follows them, it doesn't disappear. So that is the departmental baseline, and that applies to IEB and Cambridge and whatever. And for me, our coaches need to be governed within that context, okay, including club coaches, but slightly more complex, because schools at least have some leeway to impose things on the employees, where the clubs they are so much more difficult to regulate. But they should still, for me, act in the spirit of the fact that we need to have a certain kind of person working with children. And the sporting gold standard is the UNICEF Safeguarding Guide. So what UNICEF has done with the International Organizing Committee and with sort of this federations is they have issued a international safeguarding guide, particularly for Olympics. And there's about 40 hours of lectures on it online on the International Olympic Organizing Committee from the London Olympics, where they said these are the things we need to look into to keep sport safe. So that safeguarding guide is downloadable. It is completely amendable, and it is meant to be made relevant to your context. But it's a very nice template, and it's an international standard. So it takes into consideration all the international stuff, whereas the minimum standard, which I will send you, and the DBE policy take into consideration our law, as I've explained it to you, plus the law of the department that governs your registration as a teacher, doesn't govern your registration as a coach, and governs the employment of an educator, which doesn't govern the employment of a coach. But within your contracts of employment with your coaches in the sport context, you can include those things, because they're your content, they are your they are your contracts with your coaches. So essentially, what we are looking at is we are looking at communicating the fact that people who choose jobs with children can sometimes choose those jobs to gain access to them, which is career offenders. We need to be warning educators, coaches, parents, and young people about grooming. We need to be putting in place boundaries to make sure that the boundaries remain professional and don't sort of blur over into the personal. And we need to be putting processes in place that if something goes wrong, how do we deal with them? And that as a system is sort of a kind of like a nurturing care framework. It's a care framework that says sport is potentially so wonderful for children and offers such wonderful opportunities for them. However, there is a level of socially sanctioned deviance in sport that we need to guard against. Boundaries are easier to blur. People change in change rooms. Coaches walk through change rooms. Coaches get in the water in water polo when they shouldn't be getting in the water. They will teach children to cheat by grabbing, like happened in the Parktown case, by grabbing one another's penises underneath the water, and that put your opponent off. Initiation rituals of rubbing deep heat on boys' penises because that, for some reason, is some kind of initiation ritual. Those are sexual assault, and we need to deal with them as assaults on the sexuality of developing young people, and particularly boys, because boys, there is a massive disincentive to disclose abuse as a boy. Are you, do they see you as gay? Cowboys don't cry. Why did he choose me? Why didn't I fight back? I should have fought, etc. And within that context, you develop a big sort of level of secrecy, and the secrecy is the power behind the abuse. Bearing in mind that doesn't exclude girls from the danger. And I mean, one of the things I heard a little while ago was, oh no, we're keeping our girls safe. We're only putting female coaches on the bus with the girls. Now that means absolutely nothing whatsoever, because one of the cases I'm dealing with in another Joburg religious school is a coach who's a female teaching, coaching young girls and having sexual relationships with the girls. So the gender creates a particular sort of bias because of the gender dynamic. Some people suspect men with girls more than boys with boys. Boys don't want to talk, and girls women who are coaching girls aren't seen as being a risk, whereas they are. So it is a percentage game, of course, and obviously is mostly men abusing mostly children. So I'm not saying that is not the case. I'm just saying that don't assume that because you change the gender, everything is fine. Thank you.